Alrighty.
We have launched.
We have. Thank you for joining us. We have a special Monday night episode, and we're calling it 157, People versus Carruthers. There wasn't enough room on the title for the show to call it Usable Material, but I think Usable is probably an appropriate title for tonight's show, and we're going to talk about it. We've convened some of the brightest in the group. John Targowski, or what I like to call the professor, is on the line already. We're going to get him on shortly. We've got a long list of other people who are going to be calling in, adding to the discussion, and that's why we're having this special Monday night show, so we can get some information out. Tonight's show, of course, is hosted by Michael Komorn. That's me. Beside me, from the Birmingham Compassion Club, is Chad.
Good evening. It's nice to be here.
Welcome, Chad. And Jamie Lowell from the Third Coast Compassion Center. He, of course, is the producer that has brought all the people together for the educational process we are going to go through tonight. Welcome, Jamie.
Hello, and I want to remind people that this is the show for this week. We will not have a show Thursday night. It'll resume a week from Thursday on the 18th.
Excellent scheduling, too. Also joining us is our good friend Dewey, who's going to offer his opinion and thoughts. Dewey, welcome.
Hi, Michael. What a pleasure it is to be here with you guys tonight. A lot of brilliant marijuana minds in the room.
We're going to try to keep you entertained as well, my friend. And we want to give a big shout-out to his wife, of course, Pam, who we hope is listening and adding to our listener count that we look to every week. Anyways, we've convened. Oh, also on the phone, of course, we've got our one of the other contributors every week, Rick Thompson. I see he's waiting. He's going to offer up some news and his thoughts and comments shortly when we get to the callers. And the convening of the people that we've and why we're doing it on a Monday is because there was an important ruling with the Court of Appeals. For right now, it's arguably the law of the land. It's the case of People versus Carruthers. And we want to examine tonight what does the recent Court of Appeals concerning People versus Carruthers mean. Extracts and concentrates, usable material, unusable material. In a decision by the producer, prudently, wanted to discuss these things tonight and help understand if what protections have been removed from this decision, what about extraction and concentrate, and what can people learn from this. As mentioned by Jamie, we will not be having our show this Thursday, but we'll resume the following Thursday with more up-to-date and timely information, pending no other strange Court of Appeals opinions. I just want to also mention again John Targowski on the phone, and we've got Rick Thompson waiting in the wings. We also have a number of other caregivers will be calling in, offering some of their thoughts. We have about extracts and medibles. We're going to have one of the technicians from Iron Labs, and we're going to get right into it. I want to also just quickly thank the sponsors, Komorn Law, 1-800-656-3557, MichiganMedicalMarijuana.org. I want to thank all the moderators, administrators for helping provide a safe environment for the community to learn about medical cannabis and involve the conversation. Kevin Spittler, Ostamo, Michigan, and, of course, the Marijuana Rancher, 313-422-5281. Okay, so we are here to talk about People versus Carruthers. And I'm going to go through this. I've got a 19-page blog that I just wrote. I encourage people to go and read it. I'm not going to go through the whole thing, but I've just got different parts broken down, and I want to get the professor, as I want to call him, Targowski, on to add his commentary and take over and co-host the show with me. But anyways, court's ruling, People versus Carruthers. Carruthers, the accused, is not entitled to immunity under Section 4 of the Michigan Medical Marijuana because the marijuana that was possessed was not usable as defined by the Act. The defendant possessed an extract of marijuana that was infused into a food product, and thus the material possessed was a substance outside the definition of usable material. Section 4 of the Act only protects a registered patient for their possession of usable material and not marijuana or any other form of marijuana that is not within the definition of usable material. Usable material is defined differently than marijuana. Usable material is a very, very specific definition, so says the Court of Appeals. And it says that usable material is defined in Section K of the definition as the dried leaves and flower of the marijuana plant, comma, any mixture or preparation thereof, but does not include the seed stalks and roots of the plant. Therefore, any substance or material that is possessed by a caregiver or a patient that is not the dried leaves and flowers of the marijuana plant and any mixture or preparation, excluding the stalk seeds of the plant, is material that is not within the definition of Section 4's immunity protection. All other materials are not. Now, what was interesting in this opinion, and there's a lot of things to pick from here, is that they spend a great deal of time, the Court of Appeals, in comparing and analyzing the two different definitions and the terms which are marijuana, which is a term that is defined in the Public Health Code and is essentially all aspects of the plant, and the definition within the Michigan Medical Marijuana Act, which is usable material. They took great pains to make the point that the Act says that a patient can possess no more than 2.5 ounces of usable material, and the Court of Appeals wanted to make the point that these words must be interpreted as they think the plain reading would suggest, although I disagree, but that those words mean specifically that immunity goes along with the possession of only usable material and no more than 2.5 ounces of it. Said again, that the protections of what can be possessed under the immunity protections of Section 4 is only up to 2.5 ounces of usable material. Usable material, as we just discussed, is defined as the dried leaves and flowers of the marijuana plant. So anything that doesn't meet the definition of dried leaves and flowers of the marijuana plant arguably would be unusable, and therefore an individual is not protected in the immunity section. I had a case not too long ago which resulted in a Section 8 dismissal, but the individual had cut down their plants, was driving in the vehicle, taking them somewhere. At the time, maybe it's the time to revisit this, we argued that those things that were in the car were not plants, they were something else. They were unusable material. And then, of course, there was no weight that could be attributed because it was just unusable. It was just some material that didn't count. And many people have adopted this concept. The thing's laying over in the corner, that's not usable. Well, this opinion speaks to that. It says that the only thing that an individual is protected from possessing and getting immunity is the usable material, no more than 2.5 ounces of what would be the dried leaves and flowers of the plant. And there's a lot of problems with this, of course, and the meaning for it regarding patients and caregivers is that while we've come to realize that what was not considered usable or believed to be usable, the logic is always followed for caregivers and patients that it didn't count towards their 2.5 ounces of, and you'd see fingers go up and quotations made of, usable material, when in fact all that is we've become to know as unusable material, not counting towards the weight, is now material that is not protected in the immunity provisions. So therefore, what is a registered patient or caregiver allowed to possess and still have immunity from arrest? Unfortunately, and with ill words, I say just those things as defined in usable material. What would a patient be? What types of marijuana if possessed will exclude a patient from immunity protections of Section 4 of the Act? And the answer is any other delivery system that does not come directly from the dried leaves and flowers of the marijuana plant would seemingly suggest that it's unusable material. One of the very, very bizarre ways in which they come to this conclusion, the Court of Appeals, is that they find that the extract of the plant, some processing of the marijuana, removing the medicinal qualities of the plant into what have become known as extracts, by whatever process that may be, butane, butter, isopropyl, ice, whatever it may be, whatever that process is. In doing so, you are removing something from the plant that is no longer defined as usable material. And as it gets into an extract form to be used for any other types of lotions, food, topical, non-psychoactive, all of this fits unfortunately, the definition of unusable material and thus is not protected in the immunity section. Now, there's a lot to draw out of this, and I have many of the definitions and portions of the Act as we get John Targowski on. But before we do that, I just want to point out some of the most egregious sections of it and why this is such a poorly written opinion. To me, the most egregious portion of the opinion and my biggest disagreement with the Court of Appeals are the several references to the intent of the voters that are made and the references to the health and welfare of its citizens, while at the same time rendering an opinion that will effectively deny immunity for medicinal use of marijuana by any delivery system other than smoking or vaporizing. The Court of Appeals says the evidence reflects that the amount of THC contained in an edible cannot be measured, at least not with testing methods commonly used in police laboratories. This is in one of the footnotes, and it's interesting to note that this footnote that is taken from the testimony from the transcript at the hearing at the trial court is used to point out the fact that the police laboratories cannot test for the quantity of THC. They can only test for the presence of THC. And the Court of Appeals goes on to say, this is my favorite part, given the unmeasurable nature of the highly potent THC contained in such edibles, the health and welfare of the Michigan citizens would be threatened, and prosecutions for possession and use of edibles containing higher than allowed quantities of THC would be systematically thwarted. I can tell you that this is this is a highlight in insanity of judicial writing. I mean, there is so many ways to unravel this and just show how it is just off in every regard, other than missing the general intent of the voters. The beginning of that paragraph, the unmeasurable nature of the highly potent THC. The opinion recognizes that the law enforcement community cannot measure. They call it unmeasurable, but it is measurable because the person that made it knows exactly how many grams of oil extract, whether it's in butter, what have you, goes into it. So it's not truly unmeasurable. The only people that can't measure it are the law enforcement community right now. They don't have the system to do it, and therefore, because of that, Court of Appeals concludes because the law enforcement can't measure it, we are going to call it all out. None of it's allowable, and we're going to use a definition to get there. Further, they go on to say the unmeasurable nature, this material that we cannot measure, and use a footnote directly from the lab tech who testified, the unmeasurable nature of the highly potent THC. How can something be highly potent when you cannot measure it? And this is where the Court of Appeals continues to go off on the crazy train. Unmeasurable natures of the highly potent THC contained in such edibles, so they can't measure it, that despite the fact they can't measure it, it's highly potent, even though they base not one citation, no reason to believe that it is potent or dangerous, that because of this, what they say, even though it's baseless, the health and welfare of Michigan citizens would be threatened. Who? Who are the people that are in possession of these things that are going to be threatened? Is it the patients who are making it for themselves, and therefore, because it's not directly made from the plant but through an extract and then into the edible, that they should not have immunity from arrest, and that the protection of the Michigan citizens would be better caused by arresting that patient? I mean, is that really what the Court of Appeals thinks Michigan voters intended? And as they go on to cite and refer to various commentary from the and try to rely upon something about the Michigan voters, I couldn't help but be reminded of a couple of circumstances that I think are relevant, and I'm going to get the phones with our friends. One is that this suggestion within the opinion that the Michigan voters want to see people that are ingesting edibles, I disagree with in every aspect. I think that the most Michigan voters did, in fact, foresee other methods of ingestion, or said another way, that the only delivery methods should not and would not be smoking. I remember not too long ago, our good friend in the Oakland County Prosecutor's Office, Jessica Cooper, had made a comment at the time that she couldn't understand how 55,000 patients, the number on the registry at the time, patients would have been recommended to smoke anything by a physician. And I thought to myself, that's so silly because so many people are ingesting all these other methods of, other forms of cannabis and receiving benefits, whether it be CBDs and or non psychoactive or lotions or topical. And the comments were that the evolution of the caregiver community has been at light speed, and that's the Cro-Magnon prehistoric mentality, because you're wrong, prosecutors, that there are all these other ways to ingest cannabis, and the community is utilizing all of them. And, of course, this opinion sets all of that back, and all of the hard work of the Michigan caregivers in evolving it seemingly right now is being challenged. The other, I guess, final point, and then we're going to get on the phone, and I keep threatening that, was that...
Michael, is this a rant?
It is a rant. And in the end, nothing about Section 8 standing on that was affected in any way, shape, or form, despite the fact that these items are not going to fall within the protections as outlined in the usable material, Section 4. Those that are prosecuted are found to be outside of the immunity protections can still assert a Section 8 defense.